Fine. Starting the webinar.
Good afternoon and welcome to the 7th and final webinar of the Digital Dialogue series on the progress and challenges of national efforts to address impunity for sexual violence in conflict. I'm Chloé Marne-Bassanger and I'm the team leader for the UN Team of Experts. Almost a year ago, the Team of Experts launched its Digital Dialogue series to reflect on the positive development and forthcoming challenges regarding fight against impunity for conflict-related sexual violence, building on the content of the special issue that the Team of Experts prepared together with the Journal of International Criminal Justice. Today, and to conclude the first Digital Dialogue series, we decided to focus our conversation on gender, and more specifically on how notions of gender inform perpetration, experience, and understanding of conflict-related sexual violence. Indeed, in recent years, we have seen an increased understanding of conflict-related sexual violence as not reflecting a simple dynamic of male perpetrator and female victims. This realization has reached not only academic literature and international crimes prosecution, but also the UN Security Council, whose resolution focused on the Women, Peace and Security agenda, now also acknowledge men's and boys' exposure to conflict-related sexual violence. But as we'll see today, we still have a long road ahead of us. To discuss this with us, we have 5 leading experts, author of the special issues and practitioners who will help us reflect on the relationship between society and courts. And more specifically, the panelists will allow us to understand how norms around gender inequality fuel conflict-related sexual violence and how gender biases or stereotype influence judicial responses. To guide this final dialogue, I'm truly honored to welcome Kim Thuy-Selinger, the director of the Center for Human Rights, Gender and Migration at Washington University in St. Louis. She'll be the last host of our team's Digital Dialogue series. Kim is one of the world leading academic and practitioner on the issue of both sexual violence related to armed conflict and forced displacement. In addition to having conducted extensive field research throughout Africa, Central America, South Asia, and Europe, Kim also provided extensive technical support to judges, prosecutor, victims counsel, and investigators in international criminal law trials, such as the case against Hissène Habré. I will now turn this dialogue over to Kim. Thank you so much, Kim, for moderating today.
Thank you, Chloe, and thanks to the Team of Experts for what's been an incredibly stimulating series of dialogues. It's really our honor to help facilitate this final episode. A little housekeeping first. I was asked to inform everyone in the audience that you can ask questions of the panelists in the Zoom chat. We'll gather them throughout the initial part of the program and pose them in the Q&A session at the end of the webinar. The chat's unfortunately not available to viewers on YouTube Live. All right, so today's dialogue promises to be an ambitious wrap-up of the UN Team of Experts Digital Dialogue series. We're taking on the core and thorny issue of gender norms and justice, as Chloe explained. And so as many of you are quite aware, we have in recent years seen an increased understanding that conflict-related sexual violence doesn't adhere to a simple binary of male perpetrators and female victims. Our first step, if you'll recall a few years ago, was the slow acceptance that men and boys can suffer it. We saw empirical data from Kirsten Johnson, Lynn Laurie, and other academics. We also know by now of the incredible work civil society groups like the Refugee Law Project in Uganda are doing with male survivors. And many of us have had the chance to work with incredible survivor advocates like Kobasia Hausu and Aimee Moninga. We're also slowly starting to grapple with the fact that women can perpetrate conflict-related sexual violence. Again, we have that earlier data from Johnson and Laurie, and other scholars like Laura Schoberg have long highlighted female perpetration of violence. And we recall the participation of female nurses in Nazi sterilization experiments, or the more recent cases of Pauline Nyamura-Suhuko at the ICTR, or Martina Johnson in Belgium, for example. Similarly, there's also increasing awareness that conflict-related sexual violence is inflicted upon and suffered by individuals across the spectrum of gender identity and sexual orientation. We have, however, far to go before the conflict-related experiences and needs of LGBTQI individuals are properly accounted for in our judicial processes. Finally, the challenge of gender bias in our judicial response is not simply a matter of inclusive understanding of what happened to whom. Social norms around gender seep into how we even go about the justice project institutionally. Not only how we take gender analysis into account for a conflict, but how are we staffed and how are proceedings run? How inclusive are our reparations mechanisms? So today we're wrapping up the UN Team of Experts Dialogue series by asking what might be the million-dollar question. It has a few subparts. What is the relationship between gender norms and socialization on one hand, and judicial response to conflict-related sexual violence on the other? Is it a one-way street with gender bias infiltrating how we understand a conflict, how we investigate its atrocities, and how we set up and run tribunals? Or is there also a possibility of it being a two-way street with the pursuit of justice for these crimes somehow also feeding back into social norms about gender and violence? So with that, I'd like to start by giving the floor to our first panelist, Professor Elizabeth Wood. Elizabeth is currently the Franklin Mussey Crosby Professor of the Human Environment and Professor of Political Science at Yale University. Her empirical and analytical research in comparative politics, focusing on sexual violence during war, has contributed immensely to the discussion and understanding of conflict-related sexual violence patterns in Latin America, Asia, and the Middle East. Elizabeth, it's a pleasure to have you with us today. You are best known for having pioneered the study of variation and how, when, and why conflict-related sexual violence is perpetrated in conflicts around the world. More recently, though, you've also contributed critical nuance to the traditional notion that conflict-related sexual violence is either opportunistic on one hand or strategic on the other, by pointing out that in some situations, sexual violence can instead be more of a practice of war. So I was wondering if you could briefly explain this sexual violence as a practice of war idea first.
Thank you very much for inviting me to be part of this digital dialogue. In analyzing patterns of sexual violence by armed organizations during conflict, I came to see that fitting them into those two categories couldn't be done. Let me explain. Scholars have shown that those patterns vary sharply. They differ in form. Some organizations engage in just a few forms, for example, rape. Others in a wide range that may include sexual slavery, sexual torture, etc. They differ in targeting. Some target only girls and women, sometimes of a particular ethnicity. Some target boys and men as well, often with sexual torture. Some target those with non-heteronormative sexual orientation, gender identities, and gender expression. And the frequency varies sharply. Some organizations engage in very little rape, for example. On the part of others, it is extremely frequent. It was in trying to explain those differences that the inadequacy of the two categories, strategic and opportunistic, became clear for several reasons. First, while some organizations do adopt some form of sexual violence as military strategy, as in some cases of ethnic cleansing or genocide, others adopt some form as a policy, but for other reasons, most often to manage the sexual and reproductive lives of its members. Second, strategic is often understood to be ordered, but organizations that adopt some form of sexual violence as policy may authorize rather than order it. The Islamic State authorized its combatants to enslave Yazidi girls and women, but did not order them to do so. Third, and this is where the concept of practice comes in, taking rape as an example, it is often assumed that when members of an armed organization do rape frequently, it is therefore a strategy of war. but rape may be frequent without having been adopted as a strategy or any other kind of policy. In these cases, it is tolerated by commanders and driven not just by individual opportunism, but by social dynamics among combatants who see it as entertainment or as a way of proving or ensuring group loyalty, as in the case of forcibly recruited combatants. In these cases, rape is a practice rather than a strategy or any other type of organizational policy. This graphic may help clarify what I mean. The rows answer the question, is this form of sexual violence against at least some social group a policy? And the columns answer the question, do commanders tolerate non-compliance with the policy? In the case of a practice, the answer to the first question is no, it's not a policy. The answer to the second is yes, commanders tolerate it. Of course, it's too simple. There are gray areas it doesn't capture, but it hopefully conveys the point when that deadly combination of commander tolerance and combatant social dynamics emerges, rape or sexual torture or some other form may be quite frequent, even though it is not a policy.
Thank you so much, Elizabeth. I'd like to ask a follow-up question, which draws on your work on variation also, actually. I'm wondering, in what you've studied in so many different data sets and situations around the world, do you have thoughts as to how gender norms inform variation in conflict-related sexual violence, and also how gender norms inform the practice of sexual violence in war?
Yeah, thanks for that follow-on. Differences across armed organizations in their gender norms, including their gender hierarchies, is a key reason that their patterns of sexual violence differ, that is, vary. Gender norms differ across organizations for two reasons. First, they differ across peacetime societies in the first place, and they differ because gender norms are malleable. They may be reshaped within armed organizations. So, for example, some armed organizations adopt ideologies that include explicit norms that prohibit sexual violence, and they inculcate those norms through repeated indoctrination and punish their violation. Others have ideologies whose norms legitimate some form of sexual violence against a particular group. The Islamic State's ideology justified the sexual enslavement of Yazidi women and girls under conditions that it defined in formal regulations, yet it strictly prohibited the enslavement of Sunni Muslim girls and women. In the case of sexual violence as a practice, and taking rape as the example, if frequent, gender norms that support rape are held by both combatants and commanders. Commanders may tolerate rape because the suffering of those targeted doesn't matter compared to the cost of prohibiting it. That's a calculation that reflects their gender norms. Combatants may hold such gender norms because their own society's norms support rape of certain social groups, a case of continuity with peacetime norms. But they may come to act on new gender norms due to those social dynamics within the organization. This is a rupture with peacetime norms. So there are important implications for the investigation and prosecution of conflict-related sexual violence. Here I'm drawing on recent work with our moderator, Kim Seelinger. First, because some armed organizations engage in very little rape, sexual violence is not inevitable during war, and therefore perpetrators, and in many contexts their commanders, can be held responsible for these crimes. Second, the centrality of gender norms, be they carried over from peacetime society, innovated by combatants, or inculcated through indoctrination, underlines the importance of gender analysis in the investigation and prosecution of sexual violence. Third, because a policy may be authorized, not orders, investigators should look for evidence of commander authorization as well as orders. Fourth, understanding that sexual violence may occur as a practice may help link direct perpetrators with higher level commanders through modes of liability such as command responsibility, aiding and abetting, joint criminal enterprise 3, and common purpose. More specifically, when sexual violence occurs as a practice, it should be feasible to establish its foreseeability. The observed variation in sexual violence across organizations in general should motivate investigation of the complete pattern of sexual violence by the particular organization. With what forms of sexual violence did it target different sexual groups? That is, investigate all forms of sexual violence against as suffered by all social groups. Thanks very much.
Thank you so much, Elizabeth. It was a pleasure to work on that piece with you, I have to say. I look forward to more pieces together. And your point about sexual violence as practice always makes me think about how we've been investigating and prosecuting these cases already. It's not really something unfamiliar in the courtroom, in fact, with the case pattern. So I think a lot of the ICTY cases, the Kunraj and Kovac case, where commanders essentially detained, humiliated, and abused women for their own personal gratification, Kovac in particularly inviting a steady stream of friends and acquaintances to visit and do the same. And it was social norms about gender and power in that community of soldiers that allowed that to happen without order and also without punishment. I think we have many examples of practice of sexual violence in war that have already entered our courts. Thank you. I want to turn now to actually another old friend, actually, Ms. Lydia Mutiani, who is dialing in from South Sudan. She is a Kenyan human rights lawyer and expert on prevention and response to gender-based violence. She's held many important positions in the past, including working with the International Criminal Court as a field officer, helping to represent victims in cases there. And she's also the former deputy executive director at the Coalition for Violence Against Women in Kenya. So welcome, Lydia. As I said, you've represented survivors of sexual violence in Kenya for a very, very long time and have worked both at the domestic and international NGOs and levels focused on gender-based violence. More recently, you actually co-led a successful case in the High Court of Kenya against the state, charging failure to uphold constitutional obligations to protect and provide remedy to male and female survivors of sexual violence during Kenya's post-election violence in 2007 and 2008. So I'm wondering if you could start by telling us about the sexual violence committed against both women and men during that time and the social meanings behind those acts.
Thank you very much, Kim. It's a pleasure to be part of this panel. Thank you. So sexual and gender-based violence during the 2007-2008 post-election violence in Kenya was rife. It was widespread, it was targeted, and it was systematic. I mean, the statistics are not exactly clear, but the Commission of Inquiry into the 2007 post-election violence documented at least 900 cases of sexual violence, which had been reported within a 72-hour period in only one of the major hospitals in the capital city of Kenya, Nairobi. So this figure was stated to be a tip of the iceberg. So we don't really know how widespread it was, but we do understand that it was much more widespread than we actually know. And it affected women and girls, men and boys, but of course disproportionately affected women and girls. Women and girls suffered wide-ranging forms of SGBV, including indecent acts, forced nudity, rape and gang rape, both vaginal and anal. And there was a noted enhanced brutality and aggravated circumstances which came with this particular act. For instance, multiple incidents which were perpetrated by groups of armed militia or state security agents on one victim or a group of victims. There was rape in front of family members for both men and women. And there were, for instance, objects forcibly inserted into the genital organs and the pouring of acid, for instance, on victims. So when it comes to the social meanings, when it comes to the SGBV against women and girls, there were certain, of course, the gendered notions that women are passive, weak, they're devalued, deemed to be objects for use and abuse. And also women are subjected to proxy violence because they are viewed to be the property and pride of their husbands, the men in the communities. So the women's value is normally calculable through this androcentric analysis, which directly links them to men. And of course, paradoxically, women are often seen as the heart of communities, and you rape them, you destroy the fabric of the communities in general. Now, the SGBV against the men and boys was limited, but it was distinct. There was, of course, cases of anal rape, and this was coerced rape in many cases. Men endured rape so that their wives or children were not raped, or men who were raped in front of their families. Of course, this was aimed to punish, to destroy, to subject the men to great indignity. And of course, because of the value of men in African communities, this was directed to destroy that particular community. But there was also forced circumcision and also penile amputation, often which was partial penile amputation. And many of these cases were registered against males from the Luo community. These acts were perpetrated by non-state actors, mainly from one ethnic group, which believes that to be a man, you must be circumcised. And of course, circumcision has ethnic and gender dimensions in Kenya. In the Luo community, traditionally, men would not be circumcised. So you are a member of that community as a man. So there's the membership to the ethnic group, but also a man, the gender and the sex binaries. So the condition and situation of having foreskin is directly linked to masculinity and manhood, the concept of being a man. And when that is taken away forcibly, of course, there's going to be an intrinsic tie and a linkage to how that affects sexuality. So it was meant to impugn the membership of these persons to a particular ethnic community, to destabilize or destroy these ethnic communities, but also to impugn the victim's masculinity and by extension, their sexuality.
Thank you, Lydia. Can I ask, given those very, very clear social meanings in the Kenyan context, how were diverse survivors' experiences presented and understood by the two different courts that you had the opportunity to engage with, meaning the International Criminal Court and then the Kenyan High Court?
Thank you, Kim. So when it came to the National Court, I'll start there. The SGBV, which was experienced by women and girls, was accepted. It was readily accepted. Even during the arguments in court, you could see that they weren't really arguing about that being sexual violence. But when we argued around forced circumcision, the government would argue that this is ethnic-based violence, not gender-based violence. And I'll get to that a bit later. And in the court's judgment, you found that there was no overt analysis of sexual violence in its different manifestations. And this, of course, included no analysis on forced circumcision. So we presume that the High Court categorized it as sexual violence, so we'll take that as a win. And also the fact that they recognize that sexual violence is a violation of a multiplicity of rights, including the prohibition of torture and the right to equality and non-discrimination. So that was well understood. But also in the court judgment, unfortunately, the court did not find that the state was liable for acts which were committed by non-state actors. And this meant that the victims of violence which was perpetrated by non-state actors were not found deserving to receive reparations, especially compensation, which was ordered by the court. So the National Court created this dichotomy, and I call it a dangerous dichotomy because not only does it devalue or delegitimize the experiences of victims who are violated by non-state actors, but especially including male victims who are mostly, if not exclusively, violated by non-state actors in Kenya during this period. The court also did not properly appreciate and understand the barriers faced by victims when reporting violations. And you would understand, of course, women and girls in many cases do not report owing to various barriers, including stigma. But this is more so suffered by male victims who are notoriously unable to report SGBV violations. It is deemed that a man is less of a man if he underwent sexual violence, such as forced circumcision, and if he did, more so when he reports an act of sexual violation. Now, at the level of the International Criminal Court, forced circumcision was unfortunately categorized and charged by the pre-trial chamber during the confirmation of charges as an inhumane act, not an act of sexual violence. The ICC overtly stated that this violence was ethnic-based, an act imposed to show ethnic superiority by one tribe over the other tribe. However, the ICC did not go the extra step to make a further nuanced link to gendered notions and norms which are attached to the act of circumcision and forced circumcision, which could have classified the violence as gender-based violence. We have to remember, just because a violation is one thing does not mean that it cannot be something else. When it comes to this particular act, it was meant to vitiate the victim's membership to the Luo ethnic group as a male, to destabilize that particular ethnic group. And also it directly infringed on their masculinity and their sexuality by extension. For instance, if you think about the impact it had on its victims, men and boys, we recorded that they were unable to have erections or engage in sexual intercourse. If that's not a link, not only on vitiating, or violating their sexual organs, but their sexuality, it could also be comparable to enforced sterilization.
Thank you, Lydia. Thank you so much for bringing a very specific case to our attention. and also for raising the issues of intersectionality, which we are just really starting to get our heads around in international criminal justice world, I think. And here, the illustration of gender and sex, but also ethnicity and multiple targets an individual may have on their back. And also for highlighting the way the same set of facts can be understood by an international tribunal and a domestic tribunal. Actually, there may be a gap there based on either proximity and understanding of cultural relevance, or just the biases that may be baked into our institutions at any level. Thank you for that, Lydia. I'm sure we'll come back to that soon. I'd like to move now to our next panelist, who is Professor Mark Drumble. He's the class of 1975 alumni professor at Washington and Lee University School of Law. As a renowned scholar focusing on international criminal law and post-conflict justice, Mark has on many occasions reflected on the influence of gender over national and international judicial processes. I hope you don't mind my outing you right now. Mark is calling in from Rome, of all places. So thank you for making time for us today. We wanted to ask you about your contribution to the special issue, actually. You wrote this with Professor Miriam Dinov, and it was a really provocative article, actually, that focused on forced marriage in the context of the conflict in northern Uganda. And unlike most studies of forced marriage committed in these contexts, you focused specifically on the experience of men and boys that your team interviewed. What are your main takeaways from those 20 interviews, the interviews with 20 men who were, as you termed it, bush husbands during that conflict? And how do you understand their experience as related to those of their female counterparts?
Thank you, Kim, and thank all of you for inviting me to discuss this particular article. And it's true, I am in Rome. I have this very formal background. Otherwise, you'd have a lovely background of terracotta and roofs and church bells, but you've got a digital dialogue series and you've got me. So Professor Dinov and I worked together on this particular piece, the many harms of forced marriage, insights for law from ethnography in northern Uganda. And Professor Dinov, an ethnographer, conducted the field research through a team of northern Ugandan researchers in 2017 and 2018. And then I came along and added some implications for international criminal law. So it's really a joint project, but the initial research is hers. And we work together very well on it because we both believe that ethnographic research can really augment the quality and accuracy of legal intervention. And in particular, when it comes to discussing men and boys, because there certainly is a lacuna in the overall research and literature, as both previous panelists have very adroitly pointed out. Professor Dinov's team interviewed 20 men aged between 10 and 38 at the time of their abduction into the LRA. They spent between 6 and 24 years in captivity, each fathered between 1 and 11 children. What came clear over the tenor of the interviews and discussions was that these men occupied multiple roles. They were captors and they were captives. They were victims and they were victimizers. They were fathers and they were abusers. And this leads me to what I think I would identify as the two main takeaways. First, in all of their cases, they were compelled into forced marriage unions. And this maps onto even the finding in the Ongwen judgment that forced marriage was a tool of social control and organizational policy orchestrated by the most senior commanders in the LRA. And these men were coerced into it. In many instances, they said they felt little choice, or they only had little choice in this particular regard. While this does not in any way obviate, excuse, neglect, or refuse to acknowledge the tremendous power that they exercised over wives and the tremendous brutalities they may have inflicted, we believe that this overall context of coercion, this overall context of a very anxious form of social ordering should also factor into the overall harms and criminalities associated with forced marriage. The second main takeaway is the interviews reveal a far more composite and complex picture of these particular men or bush husbands. Each man is not like Ongwen. Every forced marriage unit that may be compelled may have differences within that. Many of them spoke even tenderly of the forced marriage in terms of trying to make the most of it. Many of them spoke with empathy with regards to their children. And I believe, and we believe, that it's simply very important to recognize this level of nuance while also underscoring the tremendously brutal and disproportionate harms that are inflicted upon women and girls in these particular coerced conjugal units.
Thank you. Thank you, Mark, and to your co-author, Professor Denov, for the research and the analysis. I'm wondering what recommendations you might have for international and national criminal justice actors who are, countering or looking at facts of forced marriage going forward, now that we have a little more warning from you and Professor Denov to pay attention to the male experience also.
So here I have three, and I think that these particular three will help improve the projects of international criminal justice. First, that the law and the crime of forced marriage underscore and recognize the totality of the harms that acts of forced marriage implicate and coerce upon all concerned individuals, men, boys, girls, and women. And if the responsibility of commanders for the totality of these harms were acknowledged, we posit it would augment the retributive, deterrent, and expressive goals of international criminal law, notably in contexts such as with the LRA, where senior commanders implemented this system as a tool of social ordering. And a similar phenomenon also, I think is fair to say, arose in Cambodia. So we believe that shifting the frame of law from a gender-based analysis to a gender-focused analysis that takes into account broader multi-party coercion would better capture the totality of the harms while not subsuming, neglecting, or dismissing the vastly disproportionate harms suffered by women and girls in these particular units. Secondly, a number of the panelists here have separately blogged and posted about the endemic overlap, confusion, and in many ways complexities that arise between a set of international crimes, such as forced marriage on the one hand, and on the other hand, sexual slavery, enslavement, torture, and sexual violence. I believe a frame that recognizes the totality of harm of forced marriage would more accurately underscore the perniciousness of forced marriage as its own individuated crime. Thirdly and lastly, in addition to promoting, as point 2 made, coherence and singularity within international criminal law conceptually, the third point is that I believe a granular and textured understanding of the crime of forced marriage would augment rehabilitative and reintegrative efforts, would better tailor them and target them to the specific constituency at hand. And I believe, in conclusion, that another important point is that it might shift the discourse of international criminal law away from what I see as a very heteronormative understanding of violence, a very binary, traditional reductionism, which in turn I would hope we could move into a space where we recognize more gender fluidity and the diverse forms of violence. Thank you very much for your time.
Thank you, Mark. Very provocative. I'm sure that there will be some response from the audience. It does make me think about, we don't have much focus on this particular panel, but really the question of female perpetration too, and the fact that we have, we struggle in the International Criminal Justice Project to really deal with the dualism of victimhood and perpetration. And we know that there's a lot of thinking that has to happen about how we look at female women who are perpetrators, but also in their own right and in their own ways, may have suffered coercion and direct violence unto themselves in these situations also. So I think you raised this looking at men, but I think we can actually take the same lens and look at women and everybody else on the spectrum. So thank you for that. I do think that will raise some questions and thoughts in the audience. For now, let's move to our next panelist. We are very lucky to have another practitioner with us, Ms. Silka Studzinski, who many of you know. She's a human rights lawyer who we're most familiar with with your work as the International Civil Parties lawyer at the Extraordinary Chambers in the courts of Cambodia on behalf of civil parties, and all the work you did there to highlight gender-based crimes of the Khmer Rouge, like forced marriage. And Ms. Studzinski is currently head of the Victims Participation Office at the Kosovo Specialist Tribunals or Chambers. So, Silka, I'm really excited to hear from you because you have the ability to teach many people something that I just recently learned too, and that is that while we know you were in Cambodia representing victims before the ECCC, one of your clients was Sosi Devi, a transgender woman who suffered under the Khmer Rouge and who testified in case 002. We were not well situated to engage Sosi Devi directly on the panel for many reasons, so we're very grateful that you are here to sort of share some of that experience. I understand that though Sosi Devi herself suffered tremendous harm during the Khmer Rouge regime due to her sexual orientation and gender identity, she actually only testified as to forced marriage and forced displacement in the trial. Can you tell us a little more about her testimony before the tribunal and how it was received both inside the courtroom and possibly outside the courtroom?
Yeah, thank you. And thank you. And hello, Kim. And I'm happy that I can join the panel. I would, before I come to and start with a response to your question, just give you some words on the Cambodian situation with regard to sexual orientation and gender identity. We have the situation that as a result of differences in language, in culture, in Buddhism, it's a predominantly Buddhist country, the concept of homosexuality or transgender as understood in the West is not necessarily directly transferable. Rather, the Cambodian understanding of sexuality is derived from concepts of gender, character, and personality. So I will leave it with that, and maybe we can talk later also a little bit about this Cambodian context. I come now to your question, Kim, and I start with the closing order, which is the indictment at the ECCC. This indictment contained a limited number of charges, and forced marriage was included because civil parties pushed with their lawyers for the investigation of this crime. And the attempt, unfortunately, to get sexual violence outside of the context of forced marriage included into the indictment or investigations, and then later the indictment that failed. Although Suu Sotiavi reported in her civil party application and later in interviews conducted by the co-investigating judges, a number of other sexual crimes committed against her, including persecution on her sexual orientation and gender identity. Gender persecution is not included into the statute of the ECCC, but could have been subsumed under other inhuman acts. Because of the limited number of charges in the indictment, Suu Sotiavi testified only on forced transfer, and this was severed in case 002/01, as it was named, and then in the second case on forced marriage in case 002/02. When Sotiavi submitted her civil party application in 2008, we held a press conference with her, since she was the first person and a transgender woman who applied as a civil party and reported her forced marriage and other sexual crimes committed against her. This drew huge attention in the media and within the Cambodian population, and continued to be a major topic when more and more people dared to speak out about their forced marriage. This was a development also among the civil parties who already participated, but never mentioned their forced marriage, but later, when more and more spoke out, came forward with the testimony on this experience. It was the first time that children started asking their parents whether they were the result of a forced marriage. In Sotiavi's case, the LGBTIQ communities, mainly in Southeast Asia, at least to my what I could follow, praised her courage, and they were glad to see that awareness was raised on the specific crimes transgender persons were subjected to under the Khmer Rouge regime. If I look then a little bit the perception among at the ECCC among professionals, both national and international, the reactions were quite strong. They wondered, for example, whether a male can be raped, or why they should investigate forced marriages in cases where the couple stay together beyond the Khmer Rouge regime, and so on. This shows a bit the climate then within the court and among professionals, yeah, in which the civil parties were and their lawyers when they tried to push forward for investigations into, let's say, a variety of sexual crimes, including the forced marriage.
Thank you, Silke. I'd like to ask a follow-up question just based on your experience. Do you have any reflections about the inclusion of diverse sexual orientations and gender identities in our court's overall gender analysis of armed conflicts? We haven't seen a lot of this. I'm wondering if you have thoughts or recommendations there.
Recommendations. Yeah, perhaps first I would like to describe a little bit the situation at the ECCC, which, and it has to be said, is assisted by the UN. Does not have a great record on gender analysis and understanding of gender and conflict-related sexual violence. We can have a look into the baseline study on gender sensitivity, which revealed many failures. So I want only to name some of them, of these findings. There is a high underrepresentation of gender competent females in general, and in particular in high positions. There is a lack of gender-trained investigators, interpreters, a lack of prosecutorial strategy regarding the investigation of sexual crimes. So since the initial investigations did not include any conflict-related sexual violence at all, this was based on the common belief that the Khmer Rouge committed huge atrocities, but were pure regarding the commission of sexual crimes. And there was the assumption that rape was prohibited, and if it occurred, it was punished. So as a result, there was no reason for the prosecution to investigate as they saw it. So, and only through the civil parties who had a lot of rights to act, a lot of participatory rights, they could push and bring a change and shed light at least on some of the crimes that were not included before into the investigations. So, yeah, I mean, I stop here perhaps, and maybe you can say more in the discussion later. Thanks.
Okay, thank you so much, Silke. And your last remark there was also incredibly, it's just a helpful reminder about the powerful role of civil society, actually. I think we need civil society to provide and to push our courts and our systems to understand better and to include, you know, just to be more inclusive in how they think about gender and understand the acts in front of them. So I think, thank you for that. I think it sounds like it was an important element in Cambodia. We see it also obviously in Guatemala and elsewhere in Kenya, in Uganda. Thank you so much, Silke. So this brings us to our last panelist, who obviously is not least among them. I don't think she needs much introduction, but I'll have my marching orders. Our next panelist is Professor Patricia Iser-Sellers, and her contribution to the field of international criminal law and also to gender justice is widely known, of course. Beyond her extraordinary scholarly contribution, Patricia, as a practitioner, has played a groundbreaking role in many cases, including as a legal advisor for gender at the United Nations International Criminal Tribunal for the former Yugoslavia, where in 2017, Patricia was also appointed as a special advisor on gender to the prosecutor of the International Criminal Court, where the integration of a gender perspective into all areas of our work was her priority. So my question for you, Patricia, hoping you can help bring some of the thoughts together a bit, to conduct a full and inclusive gender analysis of conflict-related sexual violence, criminal tribunals must widen their aperture to include male victims, female perpetrators, people of diverse sexual orientation and gender identity, and of course, ways that gender contributes to intersecting vulnerabilities. So in light of your broad perspective on international criminal courts across the globe, please comment on the relationship between gender norms in society writ large and this project of international criminal justice. And if I could add, and when we think about conflict-related sexual violence in particular, how do social norms and the criminal justice system inform each other, substantively, procedurally, even institutionally? Thank you.
Thank you, Kim, and congratulations to the team of experts for this, your final digital dialogue. They have all been very exciting and extremely full of ideas, but also I take it that you are setting really the tone for conversations among civil society, academics, and practitioners. So congratulations again. Kim, to your question, I'd like to change it just a little bit because I think that the previous panelists have very well shown at times the inclusion of certain aspects of gender, whether it be conflict-related sexual violence against transgender, although in a minutia, or how two courts look at questions of sexual violence, cultural ethnicity, and I would also say political standing, how that intersects with gender. We have also heard about the ability for courts really to incorporate via crimes against humanity or via genocide these aspects. What I would like to highlight right now in these few minutes are two issues. First of all, that the international criminal law that was established in the 1940s, Geneva law, the Hague law, crimes against humanity, and then eventually genocide law, have, as I've said before, a doctrinal spine that is collective protection. Now, none of those bodies of international criminal law or humanitarian law ever use the word gender. Maybe we'll find the word sex under, let's say, Geneva law that we try to interpret as gender now. But neither of those bodies excluded gender or sexual orientation when they talk about the civilian population under crimes against humanity, or when they talk about racial, religious, national, ethnic under genocide, or about the wounded, the shipwrecked civilians or prisoners of war. In some ways, we're looking at what we would call our modern view of international criminal law and almost lamenting as to the lack of space in order to offer protection for the broad span of gender, sexual orientation, and gender identity in performing persons within these legal regimes. I caution that we don't exclude them ourselves from a legal basis. Now, from a practice basis, in terms of investigations, in terms of legal submissions, and in terms of adjudication, yes, this is where a lot of work has to be done. But I think we must recognize that there is more than a birth to include gender and all forms of sexual violence against all types of victims. Right now, as the law stands, we should understand and grasp that law prior to, I would think, even enlarging it. And let me give an example of two things. I am often distraught about our memory, how easily we erase it. And I'm talking about our memory of legal history. if one were to look back at Nuremberg and Tokyo, we will find evidence in the transcript, no, not necessarily in the written judgment, but in the transcript of vociferous acts of sexual violence against males, against children, boys and girls, and against females. The reproductive experiments that the Nuremberg judgment covered, and in particular the subsequent trials, is really sexual violence and gender-based violence committed against males and females. One could look at the Tokyo judgment and see vivisections, genital mutilations, cutting out children from pregnant women's bodies. This should not be thrown away. Why? It is just not a question of looking back in history. It's a question of understanding based upon customary law, the breadth of protections that both Geneva law, Hague law, international, well, crimes against humanity and genocide should offer. If I could just conclude on this first part with one other observation, and that is today how we're looking at males and females and looking at the gender spectrum seems to be rather truncated. I know that we talk about just beginning to open up this world, but I think we're caught in our own stereotypes and our own cliches. First of all, just the phrase that women hold the culture of a community. When you destroy the women, you destroy the culture. Well, I think that doesn't recognize that men hold the culture too. That when you destroy men, you destroy the culture. I'm not making a judgment on the masculinity, patriarchal nature of the culture. I'm just saying that we shouldn't limit females to being the only holders of the culture. In addition, I would state that, for example, all of the Srebrenica cases, which I call a sub-body of jurisprudence in and of itself, when the men were killed, and that has been declared and adjudicated as genocide, the reproductive capacity of the Srebrenica Muslim population was also undermined. And so relating reproductive capacity only to females is also too much of a reductionist cliche and essentialization of women and ignoring men and their gender participation of reproductive activities in which they play. So therefore, I'm going to conclude right now on this first part and would urge us to look at our law with fresh eyes as a tool, not an endpoint or a conclusion, and to look at our cliches of who we include and who we exclude. Recently, I looked back over at the Ravensbrück trials, and that's the Women's Detention Center that was ruled by the National Socialist regime. I will just say that the trials that came out of Ravensbrück had 21 female defendants, as many female defendants as there were of the major Axis criminals at the Nuremberg trials. Why have we not mined that to understand more about female perpetrators and how they reproduce or how they do not reproduce based upon the power structures that we live in now? I mean, our political, our economic power structures. I'll stop right there.
Thanks, Patty. One of these summers, I'm going to sign up for your course because I just need to keep listening to you. Thanks for all of that, the reminder about memory and the history. I imagine any academics or researchers in the audience have been taking furious notes about this call and the need to actually engage historians a little bit too, to help us get through that material, because you're right, the key to understanding customary international law and how it has treated gender and what space we've made for these nuances for decades longer than we think needs to be addressed. I had another question for you, but I know that we might share that with everybody, but perhaps you could lead on this, Patty. Before we move to the audience Q&A, I wanted to ask, maybe with Patricia leading, about the second part of what I posed from the very beginning is the relationship between gender norms and biases and socialization and our judicial processes. Could it potentially be a two-way street too? What we do in the courtroom and with these trials, what is the chance that can positively impact understandings of gender or even promote gender equality beyond the courtroom walls? And maybe we can take a few minutes, starting with Patricia, but seeing if any of the other panelists wanted to weigh in on that before we move to the full Q&A. Do you have?
Right. Kim, thank you. I will state that I believe that the courts and society are all part of the same political, economic, international community entity. And to even propose that they would be so diametrically separate in our conceptualization would be rather ridiculous. Of course, the courts have brought their aspirations as well as their biases to all of the issues that are before them. There is one thing that I think that we should note, and a little bit is, Libby has brought it out, but each of the other panelists, and that is this instance of understanding what I would call provocatively the gender ideology of the perpetrator, to understand how the perpetrator views their actions, their aims, their objectives, and how that encompasses gender. The example, of course, is ISIL the Yazidis, enslaving Yazidi females, but enslaving Yazidi children as child soldiers, transferring Yazidi children to another group, their own group, as part of a gendered perspective, but also what they have done to their own side in terms of gender. In Colombia, we know the forced administration of contraceptives to make sure that female who belong to the FARC group do not fall pregnant and therefore stop the operationalization of military efforts. So looking at this gender ideology of the perpetrator, I think is another line that the criminal justice institution can give, and that also can reflect what is actually happening out in the society.
Thank you. Thanks so much, Patty. I don't know if before we move to the audience Q&A, are there other panelists who wanted to react or comment on what Patty's given us to open up this broader conversation about the relationship? All right. Well, maybe, thank you so much, Patty. I will, we have a number of questions from the audience that perhaps we can get to. There are so many. We're trying to cull through them because the audience is incredibly engaged here and we appreciate it. Perhaps we could start one question that that can be addressed to all of the panelists actually. And that is, what do the panelists think we can do to improve intersectional understandings and analysis at all steps along the criminal justice process? And how can we best tackle misunderstandings, myths, and stigma, which are rooted in gender norms that are institutionalized within justice systems and internalized within the actors working in those systems? So I suppose, Patty, you started to touch on that already, actually quite deeply with your comments. I don't know if you wanted to add anything.
I think that some work is beginning to be done. It involves everything from understanding the legal breadth, but also doing some, and this sounds very inappropriate in a certain manner, but doing some self-reflection, asking civil society to reflect on its own biases that it brings, asking the practitioners and asking the judges. A very quick example of that is at one time civil society thought that only females who were sexually assaulted would females who were sexually assaulted would only talk to females, okay? And now we understand if you are survivor-centered, you ask the survivor. They might want to speak to an older male. We found that age was more of an issue at times. So I think this self-reflection, which doesn't sound very scientific, is how societal growth takes place and also in the legal realm.
Mm-hmm. Thank you. Thank you, Patricia. Would anyone else like to weigh in on this question from the audience?
I'd be happy to, if that's okay. Because I think your question and from the audience and the question that you posed to Patricia are deeply interconnected. I mean, I think one thing that's crucially important that probably gets under-discussed is a case is based on evidence, right? And evidence emerges in general at very, very early investigatory stages. And I think one pattern that one has seen with regards to sexual violence is investigation of sexual violence often remains an afterthought. And then as a result, we have a lag in the kinds of evidences that are marshaled. And clearly, I think in the Northern Uganda case, even though there's extensive research done early on in investigation on all forms of sexual torture against women and girls, we see a lag in posing the broader question. So I think one thing one could be mindful of is always learning from the prior experience. I know it sounds totally hackneyed, cliched, and banal, but law often doesn't really do that so much. Doctrines of precedent, best practices come in, and then there's ways of doing things, and we stick with those ways of doing things. I think thinking about going beyond existing ways and always having conversations such as this, I think can really feed back to the earliest investigatory stage, sort of this epistemology. What do we know about what happened? It really roots in what do we ask? And maybe we should ask much broader questions. Thanks.
Thank you, Mark.
If I could step in as well, just to build on the two previous points. Yes, what we learn depends on what we ask. And I think by bearing in mind some of the points made across all the panelists, we know that how important it is to ask that full range of questions. What forms of sexual violence and against what social groups, and really fill out that whole map rather than presuming that we know what happened. And as Mark emphasizes, it's really important in those initial steps. I want to also add that I think this careful attention to gender analysis, Patty's point about gender ideology on the part of the armed organization, and I would add the extent to which it is drawing on or in contradiction with the society's ideas of gender norms. That's relevant not just for sexual and gender-based violence, but that informs the full range of violence by the armed organization. So we should broaden that question still more to ask not just what forms of sexual violence were carried out against particular populations, but what forms of violence in all its diverse forms targeted which social groups. Thanks.
Thank you, Elizabeth. Did anybody else want to weigh in with this first question?
Yes, Kim, if I may. Just briefly, of course, because of my background, it'll just come out very civil society kind of input, but I think it's important because whenever we speak about levels of understanding, right? Or, like when you present something which might be something we can understand when we're discussing gender ideology, but then we have the decision makers who actually probably do not understand. They don't understand the definition of gender. They don't understand the definition of gender-based violence. And of course, this is not to castigate all these people who are extremely qualified to hold certain positions. But I think it's very important when we go back to the source, where we think about recruitment, the recruitment which is done. Are questions specifically posed, or are there indicators which are specific to test somebody's understanding on gendered notions? For instance, you cannot be a judge who's sitting in a certain position and you don't understand how to apply a gender analysis or an intersectional analysis. And this should also be buttressed, not only in recruitment, but through ongoing vetting and also continued assessment of the conduct of justice actors in how they perform their tasks, but also in the audit of judgments by what we would otherwise, speak about as inspectorate. And of course, continuous capacity building, because I would be so happy to find out that there are very many of these decision makers or these practitioners who are sitting in this particular, attending in this webinar so that they can improve their understanding. Thank you.
Thank you, Lydia. Any other thoughts on this first question? Okay. All right, we have so many others, and I'm not sure if we're able to cluster them as well as we'd like, but I wanted to ask one that came in, which sort of raises the question of intersectionality a bit, because this is something we've all been touching on throughout the session. The audience member asks, I would be very interested to hear the panelists' reflections and ideas about potential transnational, cross-jurisdictional, multidisciplinary, feminist, and gender-sensitive responses and strategies to address gender bias in adjudicating conflict-related sexual violence, also with the aim to consolidate and share knowledge and experiences. So for example, could we establish a network of professionals, ranging from lawyers, health professionals, translators, who have worked in international, regional, and national courts on these issues, who could develop a repository of best practices or lessons learned, for example, to help others pursue feminist interventions and coordinate gender-sensitive interventions in the future. It's a long question, but I think the aim of it is, what can we do? Can we create more coordination, communication, and lessons sharing to help with the way the judicial system approaches gender in their deliberations and their processes? Seems to be a specific recommendation that we create some sort of network or a community of practice. We have some on this issue already, right? We know JRR, we have different, the team of experts, JRR, we have groups that have rosters and specialists on sexual and gender-based violence and conflict-related sexual violence. The extent to which there's actual sharing and exchange beyond those teams, I'm not familiar, I'm not sure how that works, but I don't know if anyone who's more on the practitioner side has some thoughts about how we can share lessons learned.
Kim, might I just jump in for a second? This is not a direct answer, I think, to the question. So it's a wonderful long question. And yes, I wish that the community was so seamless that as soon as the decision came out that had an appropriate gender analysis in the decision, that everyone knew about it. But there is something that I've noted, and that is the language barrier. That there is beautiful jurisprudence that has come out of Argentina during its dirty wars, that's gone everything from torture, male, females, pregnancies, to children being transferred to another group via adoptions. Because most of that is in Spanish, there are certain parts of the world that do not receive it, and vice versa with jurisprudence in English, in French. And I would really say that we have to understand, if we want to be a community, we're going to have to resource and fund the translation of documents at a high legal level.
Thank you for that very concrete and actually pretty fundamental recommendation, Patricia. Other thoughts about how we can share knowledge on this issue coming from different contexts with different roles? Okay, let me move to another question here, which I don't know, Patricia, this may start with you too, because I know that you've written on this, but anyone else, please feel free to join in. Someone writes, I wonder how the CEDAW obligation of eradicating harmful gender stereotypes played into the national and international court experience regarding conflict-related sexual violence, either if courts implemented this obligation or incurred harmful gender stereotypes, or sort of promoted or continued to perpetuate harmful gender stereotypes. So maybe if we take from this question, is there a role for the human rights law and human rights obligations to inform our international criminal justice work on gender stereotypes and biases and discrimination? Sorry, I know we're putting you all on the spot with these questions. I apologize, but if anyone wants to weigh in on any of these, I'll put that one there. So maybe we'll leave that. I'll ask a couple, actually. There's another question about sort of reflecting on the article that Mark wrote with Miriam Denov and the methods, the ethnographic field work that underlay the piece. So maybe this is a question for Mark and Elizabeth. How can social sciences and sort of research methodologies help legal practitioners better understand and address the gender aspects of conflict-related sexual violence, crime, and victimization? And then I'll throw another question in there so we can each touch on whatever you like. There's another question about whether there are some best practices or approaches that could be used to ensure that judicial processes do not remain gender blind? What kind of support can international organizations like the UN team of experts, civil society do directly to support actors in the judicial process? We've touched on some of these, but just if there are additional roles you see specifically for the UN and civil society. So I'll leave those questions on the table for anyone to respond to. Maybe I'll go down and see who has some thoughts. Maybe we could start. Silke, I don't know if you had any thoughts as to any of those questions.
Yeah, perhaps only one with this, or what I would like to add is, let's say, how could then all the, let's say, expert groups, or what came in a previous question, so to build these groups, fine, they exist, or several exist already, fine, but how are they linked to when new courts are built? For example, how does this influence the selection of judges? How does the building and the statute and rules of procedure and evidence, all what comes then in a new court again and is rebuilt, and as if there would be no history, I sometimes think so, or no lessons learned, or from other courts also then transferred, and then even UN, or with the assistance of UN, a situation being Cambodia at the ECCC, where you even don't know where to start with, or so, because it is so on so many levels, different levels, also perhaps also to mention then in only daily practice in hearings. So TRV was called sometimes Mr. Witness, sometimes Miss Witness, Mr. Civil Party. Throughout the hearings, all parties, only the civil party lawyers not, but all others, judges, prosecutor, defense, all addressed her, knowing the background. I mean, this is, you can say, get this as a minor thing, so maybe it's not the main issue, but this is a starting point. It's a lack of respect, lack of thought, lack of everything. So, but how do you want to change this then, you know, when I go, let's say, further to how this was addressed and to look at the impact that the forced marriage had on her as a transgender, which is different than the impact on others. So it was all told, but did not make it into the judgment. And so then really, I mean, that is more perhaps to be addressed to those who are then starting with new courts. How can this really be bundled and be inserted in all activities around the building of a new court? And I don't know what we can expect in the future, but this is at least also what I expect, that the courts that we have here are not the last that we will deal with.
Thank you, Silke.
Oh, sorry.
If I could address the question about ethnography, we have heard already two examples, I think. Mark's co-authored article in which ethnography helped map the nature of harm suffered by male victims of forced marriage, and in Lydia's work, mapping the social understanding of the nature of gendered harm, which I'd be interested to know the extent to which that drew on ethnographic work, perhaps in addition to the legal investigation. I'd like to add two others. One is that different ethnographic methods can help map the entirety of the experience on the part, on the one hand, of victimized communities. So help map forced displacement, help map the way in which that affected family structure, help map the evolution of community divisions where from what may have been initially minor tensions and so on, but also to help map the lived experience of combatants within the armed organization. So oral histories, I think, are really important to help investigators understand the totality of life within the armed organization that is being scrutinized. In particular, to get away from the written documents produced by the organization that may paint a pretty picture of various aspects of their ideology, but what they might do on the ground, so to speak, can be quite different. And so through these oral histories with former members or members, you get a much deeper, richer picture, including how things like enforcement of prohibitions varied perhaps across commanders or varied over time within the same unit and so on. So I think there's a richness of methods just in that one word, ethnographic, that could really help a lot. Thanks.
Thank you, Elizabeth.
May I just jump in for 1 sec? Is that okay? My internet cut out for a bit and I'm back, so I'm not sure if we're done with this. Are we done with this particular?
No, I was fully expecting you to have something to say about the methods.
Yeah, but it's weird. My internet cut out, but I got back on. I know for you all, that's a small accomplishment. For me, that's a really big. So I'm feeling good about myself. You know, obviously, I find ethnographic method appealing, not only with regards to the forced marriage, but also my general work on child soldiering, and the book that I wrote on child soldiering drew a lot from that. So let's flip it. There are limits to ethnographic methods, right? And I think it's important to also be cognizant of those, right? You know, is there necessarily empiricism in storytelling? Can you extrapolate generally from the lived experiences of a smaller number of people? I don't know. And then I think there's also a conceptual tension when it comes to using ethnography to think about law. You know, law is about universalism, clear principles. It is about best practices in a sense, right? It's a normative question of the way the world ought to be. Now, ethnographic inquiry is localized, it can be individuated, it's very community-based. And I think ethnographers and anthropologists resist the push to deploy their work in conversations about universalisms and the way law ought to be everywhere, right? And that doesn't, obviously for me, that doesn't mean that those particular insights are not helpful. I wrote a whole article about how I think they are helpful. But I think, as with everything in any kinds of analysis involving the incredible painful questions of reconstruction after systematic, heinous violence, you know, there's no quick fix, right? There are many approaches that are helpful, synergies, and thinking carefully. And I think modesty is also very, very important. So I think, just as I would think about the benefits of ethnographic analysis, you know, there are limits too, important ones. And I think it's important to be aware of those.
Mm-hmm. Thank you.
And I apologize if it was said already. Well, I was cut out, but I'm cutting off now.
No, I'm just listening to you, and Elizabeth made me think about some work, the importance of the population-based surveys too. If we look at other social science methods, right? Just the Kirsten Johnson and Lynn Laurie's work I mentioned from the beginning that gave us some empirical data about who had exposure to what kinds of sexual violence in Sierra Leone, for example, and Liberia and Democratic Republic of Congo. And then I don't know if people had seen, a few years ago, Lynn Laurie put out the piece specifically about how population-based surveys could in theory help guide investigative strategies and show investigating team where in a region the highest rates of certain types of violence were occurring, so you could focus a little bit. Yeah, those are interesting suggestions, but I think there is something that the academic world can contribute to the legal world for sure. I say that in a little bit of self-serving irony, I suppose. But other thoughts to the questions that were posed or that we called in this group?
Kim, if I, yeah, thank you very much. So with regards to, I'm just going to comment on three aspects which have been raised and further discussed by Elizabeth and Mark and Patricia, of course. When it comes to ethnography, it'll just link back to what Mark was talking about before in widening the questions of what questions are we asking, but also who is consuming these investigations, right? Consuming the information. During investigations, for instance, as you find the International Criminal Court, there's the ongoing policy that people from that particular country cannot be part of those investigative teams to make sure that impartiality and independence is maintained. However, when you have non-natives conducting certain investigations, you will find that there's certain information which will fall through the cracks. So how the information is collected and thereafter presented to the court will make it difficult for this kind of scientific research or understanding on ethnic customs and practices, and how these now link to the gender norms and the stereotypes. For instance, in the case of Kenya, it was not, forced circumcision was not only to impose ethnic superiority by one group over the other, but also gender superiority, because members of the superior ethnic group just perceived themselves as men or more of men than the victims, who are apparently less than men. This is indicative, of course, of the ethnic notions, the beliefs, the practices which are tied to these gendered norms, which create a power imbalance, gendered notions which are drivers of this kind of act of sexual and gender-based violence. And then to answer the question of how do we now, make sure that this kind of intersectionality or these forms of sexual conflict-related sexual violence are better understood, I would ask, when it comes to, for instance, make certain suggestions which are already being implemented by courts, is, for instance, employing expert advisors. It could be as simple as that, like the position that Patricia holds importantly at the International Criminal Court, and also in facilitating victim participation in ongoing criminal, but also constitutional proceedings at the national and international level. Presentations by victims directly in courts cannot be understated, but also presentation of arguments by victim representatives really have come in to infuse a lot of understanding and this kind of gender analysis at the national and the international level. Thank you.
Thank you, Lydia. I'm wondering if there's time, because you set us up really nicely for just this one last question, and anyone who wants to comment briefly on it. It's a great question, and it was directed nominally at Silke, but actually also open to others, because I think everyone may have some thoughts here. And that is just a comment on what you had raised earlier, Silke, about how Western understandings, in this case, I think particularly of gender, don't translate into other cultural contexts necessarily. And so the participant was just noting that there may be an important decolonial lens here that could be brought to understanding the sexual and gender-based violence and gender norms in post-colonial states also, and importantly, how this may affect investigators, practitioners, and researchers' own reflexivity, which I think is a call to Mark's also reminder to be modest and I think self-aware of what we're each bringing in terms of our own biases to this otherwise well-intended work. Did anyone want to comment on this as our last question?
So perhaps only.
Silke, please go. I'll go after you.
Oh, sorry.
Silke, please go. I'll go after you. Thank you.
Only very briefly, because this would be really, let's say, the topic for another major, not only research, but what one can talk about. I think in the Cambodian context, and what I wanted to say is there is that other elements, like, for example, if you look at language, and language doesn't have the Khmer language, anything to do with the, not much to do with the colonization, or the Khmer language that, or the Buddhism, which is much older, that influences also the self-perception or the perception of sexual orientation. And there is, of course, something what we subsume under under these terms, but it is worth to look further into it, and before then to get an idea of what is the understanding then in this country. That is only what I wanted to say. And of course there are in our terms and understanding transgender women, transgender men, and so on and so on. But look and ask questions, learn what the local understanding is. And in this regard, I would not so much refer to colonialism and this. Maybe colonialism is also contributing perhaps, but I don't see it here so much. I only want to call listen and learn first and then go further.
Thank you, Silke. Maybe last comment from Patricia?
Yes, just very briefly, I think that we all try to worship the law as if it were the neutral instrument, okay? And we know that law is not neutral, but it is a political product of legal systems that put together law that perpetuate their societies, whether they be international communities or not. But I also think that we as practitioners or academics think that we're the neutrality that's coming to the neutrality, as opposed to seeing the limits that we bring ourselves to the limited law. And one of the examples, we'll have a further discussion of this one of these years in the future, but I am almost certain that if I hadn't been a descendant of slaves, African-American, looking at the evidence in Coonrod and decided that this is enslavement that has gone on. This is rape, but this is also enslavement, which for some of my colleagues and for some of civil society very much, in the vanguard with sexual violence has to be rape, they've never thought of enslavement or sexual violence within enslaved situations. And so it was bringing my unneutral self sometime to look at the evidence that has brought us to that point. And then we latch on to, oh, I can understand sexual slavery. All the other slavery must be when you're working in the field. It must be that masculine labor type of slavery. And we're still stuck there in some of our cliches of how we perceive ourselves and how we perceive that neutral law. So that's just my final comment.
It's a great one, Patricia, thank you. It's a good call for us to interrogate what we're bringing to the work in all of our different roles, and maybe to call each other on it when we see some challenges or problematic interpretation or biases that we're each doing despite our best intentions. I'm actually going to spare everyone some closing remarks because it was good to privilege the conversation with so many wonderful questions coming in. But just really thank you for all of the points that the panelists raised. They were wide-ranging and incredibly provocative and reminded us to not just think about inclusivity when we think about the sexual acts of violence, but the overall analysis and the totality of what we see in a conflict. But also to look to history, as Patricia reminded us, because there are some keys there and some progress that we have not accounted for, I think even decades ago. I'll just close there because I know Chloe wanted to thank you and wrap up the entire series, but really my sincere thanks to all of you for making the time today, and thank you for our audience members for joining us. I'm hoping we can have more conversation. There were many people we were hoping to engage in this issue, so whether it's up to the team of experts or one of us to organize a follow-up conversation, I would welcome it. Thank you. Chloe? Oh, please stay for Chloe. 1 second. Where are you, Chloe?
I'm here. I don't know if you can hear me, Kim. Can you hear me?
Yes, but we can't see. Oh, yes. Okay.
All right. Thank you, Kim, and thanks to all the panelists for this intellectually challenging discussion. As for all of our sessions, today's session will become available online on YouTube and the Team of Experts webpage shortly. This, as Kim just mentioned, marks the end of our first digital dialogue series, and we started this last summer out of a partnership from the Journal of International Criminal Justice and 4 stellar academic institutions, the Center for Human Rights, Gender and Migration at Washington University in St. Louis, Harvard Humanitarian Initiative at Harvard University, the Institute for the Study of Human Rights at Columbia University and the School of Transnational Governance at the European University Institute. And I think it's great that we finished today on such a rich discussion, which probably leaves us with many more questions than answers, and does broaden quite a bit the debates that we've had so far, including into some epistemologic questions. So I'm very thankful that for the past year, and despite COVID and despite the challenges that we all faced, we worked together to enhance accessibility to public discussions, designed to ensure that multidisciplinary experts, policymakers, and practitioners could have open discussions and critical reflection on the best practices and persisting challenges to deliver survivor-sensitive justice for conflict-related sexual violence. I'm quite heartened and interested to see the support, but also, the conversations that was had during this session about how do we move from there. We've received quite a lot of support from the audience, a lot of support from all the experts that agreed to take part in each session and make time for us, and of course from our partners. And this has all exceeded, I think, our expectations. And it's been truly an inspiring endeavor. I think this does set us up for a nice beginning of a community of practice, and I hope we can think together how we will pursue this and maybe drill it, maybe in a second series, but also probably through looking at how we march this forward. For now, the digital dialogues are all permanently online on the webpage of the team, and I invite you to revisit them. I think they're so rich that one vision is not enough to actually go into all of the topic and questions that we've raised. I thank you for following us this year, and we look forward to continuing this conversation. Have a great day.